Yeah, hi, ladies and gentlemen. Welcome to this webinar. And this webinar is so special for many domain name investor and as well as domain name owner also. Okay, because it's a guide for all the stakeholder of domaining. Okay, and today's topic is navigating the legal landscape of domain investing globally. And webinar would be taken by Mr. Ankur Raheja, who is the cyber and domain name lawyer and trademark expert. Also, apart from these things, he was and is domain panelist into various organizations actually, and he's also founder of Silo Solutions. Apart from that, he also runs a blog on uh, uh, cyber law, domaining law, we can say. And Ankurji, you can also please share your blog so that people, our audience, can learn from your blogs, articles as well. So, welcome, Ankurji. You can start the webinar. And before starting this webinar, first, I would like to, ask a question. Do you think this webinar is necessary for the domain name investor and other corporate world?
Yes, of course. It's always advisable that you are aware of the do's and don'ts while registering a domain name and how you can avoid any kind of legal hassles. Like if you do some kind of due diligence before registering a domain name, or even later, once you have registered a domain name, you receive a notice whether you should respond or you should ignore. All such you should be aware of so that you can protect your valuable asset, that is the domain name.
Thank you so much. So we are doing a valuable domain webinar today. So, Ankurji, I would like to invite you on the floor, and I want and all the people want your introduction first.
Yeah, basically, I am I specialize in the domain law field, so I very regularly handle UDRP and INDRP matters, and I am also a panelist with ADNDRC that is based in Hong Kong, and also a URS examiner with MFSD Italy. And other than that, I also handle trademark registration work, that is IP related matters, because otherwise as well UDRP involves trademark means a UDRP complaint comes only when there is a kind of infringement of a trademark. So it's quite related to the trademark.
Thank you so much. So, we will start with the first slide. You just tell me, I will move to next slide whenever you want to, right, Ankurji, please.
Yeah, sure, sure. Yeah, thanks. So basically starting with the basics. So as I just told that there's a quite close relationship between the trademark and domain names when it comes to domain name disputes. So basically, a trademark is could be any word, a symbol, or any brand name that is protected by a brand owner and is duly registered before a registry. That could that is mostly that is jurisdictional based. Like for India, it is the trademark registry that is basically based in different jurisdiction. Like for North India, it's a separate office, and for Western India, Southern India. But if you want to go for an international registration, then either you can apply for directly to any country, or otherwise there is an option to apply for an international trademark. So basically, if anyone wants is either starting a new business, so he can go for a trademark as proposed to be used, or otherwise, if one is already having a business, say you were already using some brand name for the last many years, so you can, of course, go with a trademark as well and show that and claim the date of usage from the past date. Like you started using some brand name from 2015. So you can always file additional information with the trademark application and claim rights since 2015. So the advantage that you get is if you are making an application as on date and say it is proposed to be used, then if anyone is already using similar mark from the past date, then the always a person who is having prior rights in any brand name or mark will always have an upper hand. So it's always better that you claim the trademark rights from a prior date or whenever possible, and you should have proper evidence in that regard. So to register a trademark, as I told, there are different trademark registries in different countries. So basically, if you are based in India, you can apply for a trademark that goes through an online process with Indian Trademark Registry, and normally it takes 8 to 9 months for the total process to be completed. But only in case if there are any objections or later if any opposition comes, then the process gets delayed. Otherwise, normally if you have selected a quite distinctive trademark and it's not similar to any existing trademark in the given class, then you can always get the registration as early as possible. So normally the very, very, and this is regarding the local trademark registration. But if you want to go for the international trademark, then that can move through WIPO only. There is a Madrid Convention through which anyone can make an application. But for that requirement is you should have one basic trademark in your own country. That will be the base application. Based upon that, you can go directly with a single application, pay the fees as per the requirement of different countries, but it get registered in various countries and cover many jurisdictions. So then coming to the domain name, so as I guess most of you must be into domain name investment or otherwise related to domain names. So domain name is basically, technically it was used to be an IP address, and just so that it is easy to remember, so that domain names came up. And the domain name system is mainly governed by the ICANN internationally, that is a voluntary organization, and always the domain name can be registered on first come first serve basis. So that is the quite relevant even from the UDRP point of view, because if it's quite a generic word and you have registered a domain name first, then you have all rights to it, and no one can claim any kind of infringement or any other violation against you. And coming to the benefits of trademark registration for domain name investor, I would suggest it's if you are holding a domain name, say you registered a domain name, and you think that someone is also holding a trademark for that similar term in some other country. So I won't say that just a trademark registration will protect you, because there are UDRP precedents which state that in case a trademark has been registered from the registrant and only just to as a say just to show off that you have also have a trademark rights, so it will not always work. But only if you are going serious that you are registering a trademark, then you should at least be able to show some kind of use of trademark. Means you are using means firstly you should have some website on the domain name so that you can show that there is some kind of business. Only then it can help in the long run. Because recently last year I remember I defended a UDRP matter for a three-letter.com, and without my knowing, the client also applied for a trademark in his home country. So it won't be appropriate to name the domain name or the client. So I think they are into unnecessary legal hassles later, because even though we got an RTNS decision and my client won, but the other party found out that they had applied the local trademarks. so unnecessary. Now they have gone into that trademark process and trying to object it, because otherwise my client was not making any appropriate use of the domain name, and he was holding it for the last more than 2 decades. So sometimes it is not always advisable that you go into much complication unless and until it is planned for a long run. Yes, that you want to show some kind of business as well, and some additional factors you can take care of. Only then I would suggest that you should go for the trademark registration if you are holding a domain name as an investment. And next slide, please.
I want to state one more thing here
Yeah,
for the last point.
yeah,
Actually, I have a couple of trademarks for my domain. I mean, I have, some good domains for which I
mm,
have, applied for the trademark, and I also got the registration also, right? But see, I also would not advise to, go for a TM registration, because TM registration is a also costly affair. I mean, it would cost something around $150 to $200 per domain, right? But
yeah,
see, I mean, what is my philosophy is like, I go for a trademark when I, you know, speculate that I'm going to sell this domain for good price. Let's say
yeah.
$10,000,
I agree.
$20,000,
That is a
$30,000.
good
In
point. Yeah,
that case, what I do, I invest in trademark. See, like I invest in domains, I mean, trademark is also one kind of, uh, uh, investment for me. Okay, if I have trademark for a domain, if I have a domain name, if I design a nice logo for that particular domain name, and if I also, register few URLs, I mean, sorry, social media handles like in Facebook, in Twitter, in LinkedIn. So I can sell the whole package, and I will definitely get good premium for that. Okay, I use that way actually. Okay,
yeah. To this I agree. Yeah, this
otherwise
is a good step.
I don't
Yeah,
think there is, such use case, but I use this for actually, right? So I'm moving.
yeah.
Okay. Can you see blue mark here, Ankurji?
Yes, yeah,
I mean, how to remove that? I mean, I think it's annotation, eraser. Hmm.
yeah.
Okay.
It's fine.
Moving to next slide. Huh. Please carry on.
Yeah. So basically, as to the domain name law, we can say that there is no as such very specific law as to domain name law, but there are some policies by different domain name registries. Like uh, there is a UDRP process that is that under which all the GTLDs are handled, like .com, .net, .org. Then for CCTLDs, there are very specific policies. Like for India, there is INDRP, and even some CCTLDs like .pk for Pakistan is handled under the WIPO system itself. So all this domain name law is governed basically by the UDRP policy or in the related CCTLD policies. And basically and there are various forums like WIPO, NAF, CIA, DRC, then ADNDRC, etc. And all these forums handle uh, these UDRP matters. And otherwise, in case of CCTLDs, the local registries handle the CCDLTs means I like INDRP matters or anything that is related to the CCDLT domain names. And
Okay, I have one question related to this just came into my mind. Like, I want your, suggestions on the same. Suppose someone did LLB from India, okay? And he wants to pursue in domaining laws. I mean, he want suppose he want to have some UDRP cases, like whether it is defending, whether it is filing. Okay, what kind of practices or what kind of courses? I mean, he or she needs to done actually.
so basically, if yeah, one is graduate in law and some kind of specialization in IP law will always help. That is related to the trademark laws. And additionally, I don't think there are very specific courses that would relate to the domain name law, but basically as to the IP law. And then we can say all the kind of UDRP decisions and precedents are online. So
Uh,
one can always go through the various articles that come as to the domain name decisions or the precedents that are available on the WIPO websites or other forum
mhm,
websites.
mhm.
So that can help gain knowledge into the domain name law.
And I think they can do cyber law courses also run by like Indian Law Institute of Delhi. I mean, they can do cyber law programs also. I think it's for 6 month or 1 year. I mean, that will help
Yeah,
in related to website thing. I mean, there could be hacking
yeah,
of domain name, there could be hacking of website actually, there could be hacking of email actually. Okay. So moving
yeah.
to next slide.
So basically, as I mentioned, as to the domain name law, so basically it is covered under from the global point of view, under the UDRP policy. So UDRP basically provides more of a kind of help to the trademark owners because in the late 1990s, when the UD, when there was no such policy, there used to be many kind of you can say cyber squatting like at that time domain names like mcdonalds.com or similar very famous brands were registered by some cyber squatters to to solve such a issue and or you can say a problem. The ICANN came with a UDRP policy so that a speedy and cost effective mechanism is there that can be used by anyone around the world because basically the issue comes is because if a domain registrant is based in India, trademark owner is based in USA, so they will always have an issue in going to another country and file any kind of civil case, and that also takes years to resolve. Like if you go to the civil code, you can easily assume it may take in India 5+ years or even in US 2-3 years plus. So the UDRP policy provides a very speedy and cost effective a summary procedure in which a complaint is resolved within a few months time. So as a result, now most of the trademark holders use the UDRP policy if there is any kind of cyber squatting or infringement of their rights. So there are many such companies who file complaint in very regular basis, like Lego is there, Teva is there, medical pharmaceutical company, and Sanofi, and many such brands who very regularly go with the UDRP action. So the role of the domain name dispute resolution basically helps the complainant, the brand name owners only to get hold of the domain names through this UDRP process as because as a genuine domain name investor, you will always try to register a generic domain name. But there are many kind of people who deliberately register domain names that are based upon strong trademarks. and they try to, means their aim is to get some kind of few $100 from the trademark owners, and those domain names are not even some kind of generic, but they will deliberately register like domain name that may include the brand name like Microsoft, or even if they are using Apple, then Apple computers or something like that. So the policy is mainly helpful to such companies, brand names. And even if you see the UDRP decisions, 97 to 98% of the decisions are transfer cases, because mainly it is for the infringement. But exceptionally, it comes, many times it happens that you have registered a very common domain name. Like last year, I handled a matter of redfield.com. So Redfield is both a geographical place in USA and also a last name. But it happened to be a trademark for some organization as well. So in such scenario, they will always try to come. They will also try to use UDRP policy, because otherwise, it could be quite expensive and a very lengthy procedure for them to come to a different country and, means, try to grab the domain name. And at country level, of course, there are policies like I mentioned, INDRP. So basically, they are quite similar to UDRP, except for a few one exception, that in the bad faith clause, you need to prove only either bad faith registration or bad faith use. But under UDRP, you have to prove both the bad faith registration and bad faith use to get hold of the domain name.
UDRPs are basically universal, and INDRP is for, I mean, dot
Yeah,
IN, for dot IN, matlab
dot IN
Indian
domain name.
domain names, like
Right.
dot IN basically, right? So moving
Yeah.
next slide, domain name protection, please.
Yeah. Just a sec. So it's quite important that one should protect the brand name, especially for the brand owner. So there are many options for a brand owner, like they can go for the variation of the domain names, like quite similar spelling if there is, or any kind of plural is there, then they can always protect such kind of domain names. Though as on date, it won't be feasible for them to go for each and every kind of extensions, given that as on date, I think there are 1,000+ domain name extensions in new GTLDs. But still, the major TDLDs and all such things can be done, and additionally, they can always trademark the brand name or the domain name, or mostly they are already having trademarks. And there are also some more important factors, like what happens is for the brand owner, they register a domain name through some web agency, and they do not take care to see in whose name the whose information is, or otherwise a domain name was registered by an employee of an organization, and it was always managed by the employee, and one day the employee leaves the organization, and then after, say, few days or few months, the organization realizes that they do not have the control over the domain name. Or even I have seen one such case in which there it was related to some famous temple in India. They were having a three-letter .org domain name, but they had entrusted with the control of the domain name with their accountant. And one day the accountant leaves the organization and migrates to Canada. So, and he was not even bothered to hand over the domain name. And I don't know for what reasons the organization was not interested in pursue the matter legally. So they ended up, instead of .org, they ended up using the three-letter .org.in. So it was, if you are not making sure that who is having the control of the domain name, then this is also a kind of hassle that you need to face as a brand owner. Then, of course, this ACPA is a special provision, special law under the in US, because any trademark owner can go against a domain name which could be confusingly similar to their brand name and file an action in a normal zip code under the Anti-Cybersquatting Consumer Protection Act, and it helps them to get, means UDRP, we can say it's a quite a summary procedure. So sometimes the complainants are not successful, so they try to use this ACPA. And for ACPA, it's not necessary that you should be situated in USA. Like if you are holding a .com domain name .org, you are in India. Registrar is Big Rocks. Suppose registrar is Big Rock, that is also in India, but still based upon the jurisdiction of VeriSign, because VeriSign is in the control of .com and .net domain name. So they can always, the complainant can still file an action in USA under the ACPA and try to get hold of the domain name. So it's really quite important that to understand that it's not necessary that we are based in India, registrar is also based in India. So no action can be taken under ACPA. Action can still be initiated. And as a domain name investor, so as a domain name investor, so we can say that initially there used to be issues that if you are parking a page for sale, so there could be two kind of parking. You could park a domain name just for sale without any PPC or ad links, or otherwise there could be a page which may generate revenue for you. So in case of PPC links, still it's a big issue because mostly, even if you are holding a very common term, but it's a brand name for some company, always revenue is generated from keywords that are more based upon some brand name and not exactly generic word. Like if domain name contains a word, say Apple, so it may not give links to someone selling Apple, but it will always provide ads related to the brand name Apple. So it's always uh, better to avoid any kind of parking page or PPC links because it can always create issues. And I'm not sure how much parking revenue is generated, but it's better to avoid it. And otherwise, if it is domain name is just parked for sale, then you are still safe because now there are many UDRP precedents that uh, uh, keeping a domain name in your portfolio is considered as a stock that you are holding, stock in trade. So you are quite safe there if you are just placing the domain name for sale. And also the legal and technical protection could be there that you can lock the domain name, keep the registrar, keep with the registrar in your jurisdiction. Though, as I provided an example of ACPL, it's an exception. Many companies won't use it, mainly those who are not located in USA. So, otherwise, if you are keeping a domain name with a registrar that is located in your jurisdiction, that may help in the matter like UDRP, because in case one loses a UDRP, then the jurisdiction is mostly based upon either your re registered, your whois address, so that will be in India, if you are based in India, and secondly, it could be the place of principal, means the principal place of business for a domain name registrar. So in that case, if say your domain name is with Big Rock or any company like even Endurance, uh, means Big Rock and some registrar were taken up by Endurance that were related to the sister concern of Big Rock, but still they are considered as located in India because the principal place of office is in Mumbai. So in such cases, such kind of protection you can take if you feel mainly some kind of legal issue could be there. Like I remember one, like Jay, you can recall, Ashwin was having some domain name I can
Yeah,
recall.
yes, yes, I can
So
recall that.
he was means apprehending that some kind of legal trouble could
Mm.
be there. So he transferred a domain name to an Indian registrar. So
Indian.
not for all kind of domain name, but such kind of protection can always be,
Yes,
such precaution can be taken to
uh,
protect the
and and
domain.
whenever this is for domain investors, whenever you are in doubt, even 0.01% in doubt, then do not park your page. I mean, doubt
Yeah.
related to if you think, I mean, there could be some trademark or there could be some, usage of similar domain name. Don't park your page because that particular, parking page can run add on that particular brand, add of that particular brand on your domain name. So this is considered bad faith, very badly, you know. So, acha, I mean, I want to ask one thing, Ankurji, like, suppose, I mean, while buying domain name, I mean, we buy so many domain names, right? And suppose there can be some cases where I don't want to, uh, I mean, protect my domain name using privacy. Okay, I want to put my address and all, but I don't want to put my number. I have seen so many domain name owners, what they do, they put their address as well, their email address well, but in the phone number field they put 1 2 3 4 5 6 7. I mean, is it legal thing? I mean, is there, I mean, any chance of trouble using this practice?
No, not exactly, because at the most, if you are not providing the correct, accurate who is, at the most, someone can complain to the registrar and registrar will just ask you to change the who is. So you will not exactly ever lose a domain name, not even under UDRP for providing a, just on the ground that there was a wrong who is provided. It could be an additional ground that some kind of bad faith or cyber squatting claim was made and some kind of things are proved against you. Then they can additionally say, okay, for the same reason this person provided the false who is as well. But but even in your example, just a phone number will never matter that much. Only someone can ask you, registrar can ask you that please uh, provide the correct who is information. So coming to the rights of a domain registration. So as a domain registration, if you are the owner of the domain name, then you are free to use the domain name whatever way you want, to renew the domain name, to transfer and keep it with the registrar of your choice. But additionally, you also have the responsibility. Like firstly, as Jayji mentioned, that you should always have accurate who is information, because mainly when you register a domain name, you agree to the terms and conditions of a registrar or a registry. So, firstly, you are responsible to comply with all those conditions and all the terms and conditions, and that includes one of the terms that whose information should be provided accurately and should be kept up to date all the time. So, these are the responsibilities, and additionally, that you should not infringe upon the trademark of other, because if when you are registering a domain name, it's your responsibility. And even the UDRP and even the say INDRP policy reads that one should avoid registering a domain name that can infringe upon the rights of a third party. So it's important that you do some kind of due diligence, like a simple Google search, if not a trademark search, to see that you are not registering a domain name that could infringe upon the rights of a other person. So coming to the next part, who to approach and process in case of domain theft. So in case of domain theft, basically this may happen unknown to you, and mostly the domain name gets transferred to another domain name registrar. So in such a case, there is a uh, policy between domain name registrars. I'll just tell you the name. Yeah, there is a transfer dispute resolution policy, that ICANN's registrar transfer dispute resolution policy. So suppose if your domain name is stolen from one registrar, but there is a time limit of 30 to or 60 days within which you need to approach your registrar and ask him to file a complaint with other registrar under this ICANN's registrar transfer dispute resolution policy. So there are still some chances that you may get your hold of the domain name if it was lost due to some kind of theft. Otherwise, if exceptionally the registrar is not satisfied that you are eligible to get your domain name back, like if the other person give other kind of explanation like he paid for it or something else, then the option could be only to go to a civil court in the jurisdiction of where the other party is, right? And coming to the next part, in case of domain theft by an employee, then in such case as well, you can either try to take protection under the policy, or otherwise a kind of civil action will be required, like an example of three-letter.org I gave you, in which the domain name was kept by an employee. So in that case, the only option for them was to the Indian owners was to go to Canada and file some action in Canada against that employee. Otherwise, they can't recover the domain name after such a long time. And even in similar things also happen with web agencies, because once a person is registering a domain name through web agencies, though as a domain name investor, you are well aware that whose information is in your name and you are having proper control over the domain names. But in case of, mostly it happens in case of layman, that web agencies keep the whose information in their own name and never give rights to the domain name registrar, so that they are able to transfer out the domain name to some other company. So in such cases, also a kind of civil action would be required, so that you are able to get, or not even in such cases, if you can show that you had the receipt, or maybe initially contacting a domain registrar could help, showing that some kind of reseller is there, web agency, who is trying to misuse uh, their power as a reseller and not giving you the control of the domain name. So such kind of strategies could be
Mhm.
used. Yeah.
Okay.
And of
Mhm.
course, enforcement agencies may not always help, like because mostly, unless and until both the parties are located within the same jurisdiction, same country, so you may not able. I cannot go to Delhi police and say that my domain name has been stolen by someone in Russia, and please help me. So that won't help.
I mean, suppose my domain is stolen somehow. Can I approach local police? I mean, whatever country I'm in, can I approach local police? Can I approach, cyber crime police? Can I do that?
Yes, to some extent you can do. They will have at least power to see, uh, to ask for the IP address from any foreign organization that who has stolen it. But still, they will not have enough teeth to go abroad and arrest someone. They will not have any such additional power, because in such cases, if someone has to arrest someone in some other country, they require some permission from Home Ministry, and quite lengthy process are there. So the Home Ministry may allow enforcement agency to go and catch some uh, hard, you can say some kind of
Mhm.
criminal, and not exactly someone who has just stolen a domain name. They may not
Yes.
uh, allow such things. Yeah,
Okay.
it is very exceptional.
That means if you face any domain related problem, whether you are a victim of that thing, whether someone has stolen your domain name, you should always consult a domain lawyer actually. Okay. And in some country, we call them IP lawyer, IP attorney, we call them. Okay. So moving to next slide, handling domain name disputes. I mean, especially for
Yeah.
domain name investors, I have seen so many domainers friend around me who got UDRP slapped on their face. I mean, for any lame reason also, and for a logical reason also.
Yeah, yeah, I can understand because in the last few years I have seen some example. Someone related were related to using word meta, only word meta, keyword meta, because many domain name investors picked up the domain names that included the keyword meta before Facebook announced the change in name, but some also got registered domain such domain name after that date. So I think that date was maybe November 2021 or 22 when the name was changed. So if you registered a domain name after that, then always in such scenario you are at risk. So in such matters like Facebook and Meta is quite active under UDRP, so they will always approach the WIPO or say forum for trying to get hold of the domain name through this summary procedure. So, well, if you receive a UDRP notice, so depending upon the facts and circumstances, now suppose you inadvertently by mistake register such a domain name that you think that it was quite a generic combination, but it turned out that included a keyword like Apple or Meta. Uh, so in such cases, it's always good that you try to terminate the proceedings so that your name is never featured in a UDRP decision. So whenever a UDRP case is filed, they always provide you an option to fill up a form and try to surrender the domain name. But even in that cases, there are some complications. Some these complainants, trademark owners, they try to means try to avoid any kind of settlement. They will just say, no, no, we are not interested in settlement. We had tried to approach you previously. You ignored our emails. Now we will just look for the decision and we are not interested. So because I have tried to communicate on behalf of some people in the last few years. So such kind of responses are also there. No, no, we have already done our hard work and now we will only look for decision. We will not accept the domain name. Though the main aim of the UDRP proceeding is to get the transfer of the domain name, and even when a resistant is handing them the domain name, but still they try to uh, ignore the request or say, no, no, we are not interested. So that is why it's quite important that you do all the due diligence before registering a domain name, because once even one UDRP complaint, your name comes and the domain name is transferred, then even in future, if you had registered more generic domain names, but still the other complainant will also try to show to the UDRP panel, see this person was already involved in a UDRP proceedings and he's a cyber squatter and all such, because they try to make their case strong. So they always try to use each and every factor or each and every strategy they can to in try to prove that the resistant is on the wrong side and they have filed a correct complaint against a cyber square. So it's so in such so when you receive a UDRP notice, if it's a strong trademark, you can still try that you are able to surrender the domain name. But in case it's a quite a generic keyword or you are having prior rights than the trademark holder and all some other different factors, like if is located in quite a different jurisdiction, you are located in India where they do not have any kind of presence and no kind of knowledge or any kind of knowledge can be enforced upon you, then you can always deny knowledge of the trademark and they cannot prove any kind of bad faith in such cases. So you need, but in any case, you need to be active in both cases, either to try to surrender a domain name or try to reply to a UDRP notice or even a UDRP complaint that is later received. So it's always good to be active and take proactive action so that later it may not happen that they come under UDRP as well and say initially we had provided him a notice as well, but they were not responding. So because last year only this happened that I tried to communicate on behalf of someone that was from this group only, from the domaining group, that it was a mistake and we want to settle. So they say, no, no, we had emailed earlier as well, but you did not respond. Now we are not withdrawing the complaint. So it's always better to be active and even under who is you should have quite active email ID so that you get proper notices in your inbox. Coming to the second part, what to do when someone is abusing with my IP with the domain name. So this is comes from the complainant side, that if you are a trademark holder as well and someone is trying to register a similar domain name, then you can always, firstly, you can always serve them a cease and desist notice. Try to ask them that stop using a domain name that is quite similar to my domain name or otherwise infringing your trademark or IP rights, or and that can be followed by a UDRP proceedings. So UDRP proceeding, otherwise you can say, are a little expensive when it comes to the complainant side, because a fees for a UDRP with a single panelist for a trademark holder is $1,500. But when it comes to the resistant side, if you are also going with a single panel, that then you need not pay any fees unless and until you opt for a three-member panel. That also depends. Before WIPO, fees for a three-member panel is $2,000, but for other organization like Forum, or there are AD and DRC, that is around $1,200 or $1,300 pieces there. So you can always go with a UDRP action if your IP rights are being infringed. Now coming to the reverse domain name hijacking, that is RDNH. This comes when this is always a kind of a decision that is against the trademark holder or the complainant, and this is pronounced when the panel finds that the complaint was brought with some malified intention and in bad faith, when the moreover when the complainant knew that it had no right to file such complaint. Because recently, or it's quite regular that such kind of matters come under UDRP, that say other a company was formed say this year only, and they filed someone on having a domain name for the last many years, like that uh, three letter I will not refer, uh, like say an example of machani.com I handled, in which my client was having the last name as Machani, though it was not evident from who is information. But the problem, but an RDNS decision was given because the complainant was not even holding a trademark for the this word, or you can say last name Machani. Because what happens is, if you want to protect a name as a trademark, then you should have a quite good amount of usage for the last many years, or kind of evidence to show that you had used it to such an extent that people will refer that last name to your services, relate to your services only. Like say Bajaj Finance. Bajaj is registered as a trademark because though it is a last name, because people could relate that it is a Bajaj group. They were having automobiles as well now, financial services. So in such cases, the trademark is granted. So in that Machani cases, it was held that the complaint means the complainant failed on all the three grounds of UDRP. That is, first, they were not having any trademark rights and not even able to prove the common law rights. Secondly, the respondent was known by the domain name, so he was having the legitimate interest. And finally, when he had registered a domain name in the year 1999, I suppose, so it was because he was known by the domain name, so there was not even a bad faith involved. So in such cases, RDNH is pronounced in such cases. Yeah. So coming to this best practices to avoid legal hassles. So for common first name or last name, you are always protected. Like I gave you an example of Redfield. Redfield is also a last name. Though in that matter, my client had picked up the domain name after the complainant had uh, accidentally let the domain name expire. So in that case, they could have claimed better rights, but still, as my client was holding it as a domain name investment, and it was a quite a common domain name, so it could not be said that he registered a domain name in a last in bad faith. So in such cases, and even this Machani case, if it's a common first name or last name, it's a .com or any kind of uh, GTLD, so you are quite protected. But when it comes to celebrity names, like exact celebrity name, like say BruceSpringsteen.com or any kind of celebrity name, then in such cases, unless and until you are able to show, like, firstly, it is for the celebrity to show that he has used his name in he has used in business or profession quite actively. Only then he can claim common law rights in his name, because mostly celebrity names are not registered as a trademark, though many celebrities may have done, but many do not register their name as a trademark. So in those cases, they need to show that they have used their name in the business or profession. So for people like actors, actors and authors, it's quite common. They are able to prove that their name is quite commonly used in their profession. So they can prove the common law rights. But as a domain name investor, if you hold any such domain name, then it's always better to build a website and try to show some legitimate interest. Otherwise, it depending upon how famous the celebrity is, they though there are some cases, I think Bruce Springsteen lost the case quite maybe 2 decades back, and some other celebrities also not able to get hold of the domain name.
Mhm.
So depending on the facts, if you are able to show that someone is using it as a fan sites, and then you can always retain a domain name, even a celebrity name.
Okay,
And similarly,
I
yeah,
have a one question, please. Sorry to interrupt you. Like, suppose, I mean, how fair it is, to book a celebrity name and develop a fan website. Okay, and there could be two scenario. First, I'm not running ads on it to earn some revenue. Second scenario can be, I mean, suppose I have aliabhat.com, and that particular site gets popular, and after getting it popular, I start running, Google AdSense ads on it, and I start earning from it. I mean, these are two scenarios. So how fair it is, because I have seen so many celebrity websites built by their fans.
fine. I got your question. So in case of a celebrity name, like you said, aliabhat.com, so if it's a normal parking page, then it will, unless and until you are able to show some kind of preparation you have made to in an attempt that you will be using that future website for some kind of fan page, as a fan page or fan website. So I don't think you will be able to safeguard such a domain name, because what happens is under either of these three clauses, under the first clause, the celebrity will always be able to prove common law rights. Fine. So they will be considered they are having rights for bringing such an UDRP action. Then under the third clause, you can never say that you are not, if celebrity is quite famous, like an Indian cannot say that I am not, never heard the name Alia Bhatt. So
Yeah.
it will always be assumed as a bad faith registration. That so your main safeguard then comes under the second clause. You need to show that you had made, or some preparations are there, some kind of there, like you appointed a web designer, you can share some invoices or some kind of things could, if something is there, then only you can safeguard the domain name. Otherwise, for a parking page, you will not able to save the domain name. And coming to the second scenario, say you said it is a developed website, right?
Mhm.
So in case of a developed website, then it will be a fan website, fan web page. Even you are, if you are earning through a Google AdSense,
Mhm.
it's quite safe because it will fall under the second clause of legitimate interest. That is a bona fide legitimate use. Yeah.
Okay.
Though even you are making money, it will be considered
Okay.
as
Somehow
a
it is
fair
quite
use.
safe. Somehow it is quite safe.
Yes.
Okay.
Yeah. Yeah.
And
Yes.
okay. And see, apart from this, see, what if these are celebrity name? What if I am booking some common names? Suppose I book amitkumar.com, ashishkumar.com. I book couple of, uh, American names. I book couple of Arabic names, right? And these people are, I mean, CEO of some company, CTO of some company, some can be professional photographer, some can be doctor. Okay. How safe it is? I mean, sh- uh, I mean, uh, I mean, what kind of measures we should take while booking and after booking these kind of domain names? Because I have seen so many domainers, what they do, they book first name and last name of any, CEO, CTO, and they approach them via LinkedIn or via, email. So how safe it is, and I mean, what is your advice on it?
So basically, as I mentioned, in case of names, it's quite easy for a celebrity to prove common or rights. But what happens is for a CTO, or for say a person who is holding a good position in an organization, they will not be able to prove the first clause under the UDRP, even though you contacted him and you registered with the knowledge that this is his first and last name combination. But under UDRP, 99% they will fail because their name was never used in a business or profession. But because take for example of the owner of Virgin Group, that is Mr. Branson, right? So he can still claim some rights because in advertisement in many places his name is mentioned. But if someone is on a lower position from him, say vice president, we do not know who is he, and if someone finds out about him and registers a domain name under UDRP, he will not be able to. He won't be successful. And even the other example that you taken, like someone registers a domain name like Amit Kumar or something, if still the same rule applies. If that Amit Kumar is Kishore Kumar's son, then there could be trouble. But
But Amit Kumar is
otherwise,
common name. Amit Kumar is common
but
name.
yeah, otherwise, so it depends what use you are doing. So it depends. It will depend upon the facts and circumstances of the case. But yes, when it is that it is a quite common name, Amit Kumar. There are many Amit Kumars. So still some defense could be presented.
We have a hand
Yeah.
raised from Deepak. Deepak, you can come on mic and you can add something, or you want to ask something, please.
Thank you, Jay. See, basically, just I want to highlight one aspect here. Names are not specifically mentioned under the UDRP policy, which are mentioned in our Indian policy. And another word, celebrity. Person should be celebrity in a sense of celebrity. People are knowing him by that name. Then only he will acquire the special right in a name, which is you do not need to require a registered trademark. Even you have a right to register a trademark name or anything which you use in a uh, commerce. Okay, then you acquire the right under the first count. Okay.
Uh-huh.
Yeah.
Anyway,
That-
Right.
otherwise I'm enjoying
okay.
from lessons from sir.
Okay, that means like names like Elon Musk, Bill Gates, Mark Zuckerberg. I mean, these kind of name you are talking about, right?
Yeah, these are something which is celebrity and people know him. Okay, it's
Mhm.
very quite as Ankur has rightly pointed out, somebody below his rank.
Mhm.
Okay, somebody second or maybe CEO, but he may not be known in a public domain.
Mhm.
So if you are known, you are celebrity, then only you get that celebrity rights, not
Okay.
otherwise.
Okay,
So that
please carry on.
that's where we. people are aware of you and your brand value of it. So it's, at the end of the day, it's a brand value created by your name.
Mhm.
So Elon Musk has created brand value for him, but what about his chief technology officer? He may not be. Sometimes
Yes.
CEO also, we are not aware unless the dispute comes. Then only ये CEO है क्या इसका? So
Uh-huh.
that's a difference.
Okay, there can be one more use case, like I just gathered. I mean, there can be parody site. There can be parody site of Elon Musk because he has given us so many reason to make parody website. I mean, I'm not saying like वो कुछ ऐसा करता है वैसा करता है. I'm just saying like there could be a parody website called Elon Musk uh, sucks.com, Elon Musk fund.com. I mean, there could be anything. There could be anything, right? So, and that web developer puts memes of Elon Musk, jokes about Elon Musk. Like, I mean, we can say about Rajnikant also. I mean, how safe it is to make parody website of some celebrity and some popular people from sports, movie stars and businessman, okay, making parody website but without crossing a line.
So in such cases, under this legitimate clause, the resistant can always claim a kind of fair use. There have been some cases in which resistant were able to protect the domain name, even though some kind of parody site was used. Even in one cases I can recall, I had seen the web page, there was quite controversial as well. But such matters, then the panel refers that they can better take before a civil court
Mhm.
to
I
resolve the matter.
I
Yeah.
I remember like there was PayPal's parody website also, paypalsucks.com. I mean, long time ago, I guess 2 decades ago.
Okay. So it also depends what kind of keyword, like if you are using keyword as sucks or some kind of negative keyword is there, then there are chances that you will be able to get off the hold of the domain name. But if it is more fair use, then
See, if
panel may always say that one can approach the civil
See,
court.
if group of people are not satisfied with some company, they will definitely use negative keyword.
Yeah.
Okay.
Yeah, such reviews website are also all yeah
Mhm.
are there.
Mhm.
So that comes under the second clause of fair use, that they are making some fair use of the domain name and they will be protected.
Okay. Now you can carry with geographical names like country like Japan, New York, etc.
Yeah, mostly geographical names, domain names are also, when held as a domain name investment, are quite safe, except if you have heard the case about the France.com, in which the French government came with the action in the US court against the domain resistant and got hold of the domain name. So it was a quite exceptional that a government said that we had right to the country and no one else should hold the domain name. Otherwise, if you are holding, like I gave an example of redfield.com, so it was also some places are there in US itself where the complainant has presence, but we were able to successfully defend the domain name. So I think for the reputed platform, Jerry, you are a better person to discuss
See,
about it.
just a moment. See, actually, what kind of problem you can face is like, never buy a domain name for from a reseller. I mean, I'm talking about like buying a domain name, buying a fresh domain name. Never buy from reseller of domain reseller. I mean, in most of the cases, domain resellers are the person who you know buy uh, I mean bulk minimum guarantee of selling domain name from a big I mean seller. In case of reseller club, what they do, they create their control panel, and they also create your control panel. Suppose you are having 100 domain names with them and thinking you control all the domain names, but the other superpower is controlling your domain name. Yes, legalities are there. You hold those domain names legally, but what if he or she cheats on you by stealing your domain name from you, a super premium domain name from you, or 20 years old domain name from you? Okay, you can do many things legally, but legal things take time. Just you can buy a domain name from investor friendly registrar like Dynadot, GoDaddy, name.com, namecheap.com. I mean, there are many. Okay, and you can also check review of the registrar from forums like namepros.com. You can also google them also. I mean, it is always advisable to buy domain names from at least a reputed buyer. And for the reputation, you can just google world's top 10 domain name registrar by number. Google it, and you can find some data from ICANN websites, and you can go for top 10 websites, and whatever price you like, whatever discount like, whatever promo code you like, just go with them. Okay, I'm not promoting here a particular registrar, but go with reputed domain registrar. And apart from that, follow domain investing ethics means, as I always say, never go behind a trademark domain name. Okay. Don't abuse. See, I got a lot of messages like saying like I can see one domain name, but that particular domain name is with someone, is sometime with multiple companies, with multiple trademark registration in multiple countries. Even then they want to book that particular domain name. It is not going to happen that trademark register that TM owner person will buy a domain name. In some cases that can happen, but that is not comes under ethical thing. In every business, even in your job, even with your family, you should follow ethics for your peace of mind, not us, for your peace of mind. Because I always say there are lakhs of domain names expiring daily, and there are thousands of domain name good domain names, and there are hundreds of gems expiring daily, and there are couple of 4 5 good domain names expiring daily. Just eye on those domain names. And I mean, apart from that, if you uh, you know uh, participate in any auction, if you win any auction, just honor that auction, paying money for that particular domain name. If you buy any domain name from WhatsApp group or from Telegram groups, or from your domainers colleague, from Name Pros, I mean, from any platform, whether it is Squad Help or something else, after commenting, after posting sold on that domain name, buy that domain name. Otherwise, think 100 times before posting your sold. Comment on that particular domain name. I mean, you have to follow these ethics to build your reputation in the domaining industry. And apart from that, Ankurji, where to check for? I mean, these kind of questions I usually get one or two a week. I mean, where to check for trademarks applications and registrations. Okay. Well, I mean, any website of USA, Australia, Canada, Indian website. And apart from that thing, I have one important question also. Suppose I'm a domain name investor in Morocco. Okay. Suppose I got UDRP notice from some company in US or UK or in India. How to handle that? Okay. This is a question from my side. Please carry on.
Okay. Can you just repeat the question? Means domain register is in Morocco
Suppose
and he
I'm from
received a
Morocco.
notice
There can be
from,
two
from other
cases.
country.
I'm from Morocco and I'm using Moroccan CCTLD for my business. Now I want to grow and I want
Uh,
to grow and I want to book a .com. But I have just checked, like after starting my business, after 1 year of starting my business, someone has booked .com for my domain.
uh,
How to file UDRP complaint about that? And suppose I am domainer from Morocco or any other Arabian country or from South Africa or North Africa, can be, right? How to go for UDRP complaint? Whom to approach?
fine. I got. So in the first scenario, as you told that suppose you started from the country of Morocco and then after the use of 1 year you realize that someone has registered a .com. So now it depends upon many different facts and circumstances. Now suppose if you are having just a presence in Morocco and you are not having any kind of presence outside, and if someone registered a .com domain name in a different country, then either your brand name or domain name should be so distinctive, or you can say a normal Google search gives the result of your brand name only, or some kind of knowledge that can be means it can be blamed upon the domain name registrant that he registered a domain name after having knowledge of the your brand name or a local trademark. Only then you can claim any kind of rights under the UDRP, or means you may have rights in a trademark that you will be able to prove the first clause, but to prove bad faith, it's quite necessary you are able to show that the other person was having some kind of knowledge from any kind of source about your brand name. Otherwise, you can't be successful in such a matter. Unless and until you can show that he is also located in Morocco or has some roots in Morocco or some kind of
Okay.
other kind of circumstantial evidence, or a simple Google search gives result of your first page for your company only, not just a single result on the second, third rank, but and there are no third users, or
Mhm.
there's a quite an exclusive use. So if any such factors are there, only then you can take hold of the domain name under the UDRP process.
Right, right.
Yeah. Now
Okay.
you will have to repeat the second scenario. You said that
The reverse
under
one.
the second scenario, okay, reverse. Now
See,
some
in one case, I am a brand owner, and in
right.
other case, I am domain name investor and got a
Okay.
UDRP notice.
Okay. I
Handle.
got it. Fine. So in that case, only firstly, of course, as you mentioned about the domain name ethics. So if you have followed all the due diligence and ethically registered a domain name that does not contain any some exclusive or distinctive trademark or a brand name of some other company, then always you can try to protect it by showing uh, providing reasoning that what was the main reason that you registered for the domain name. Like it could be a combination of two common word or one dictionary word and one other some other kind of common geographical place or anything, any combination you created.
Mm-hmm.
So if you are able to prove that anyone could can come up with such a combination,
Mm-hmm.
then of course you can, on those grounds, you can prove that there is no bad faith involved. And then,
Uh-huh.
as I gave the example in the previous scenario, so
Uh-huh.
in this case also the complainant will be able will have to prove a kind of bad faith or knowledge on your part in
Mm-hmm.
able to be successful,
Okay.
because even if you are not making a use, you are not making any legitimate use, even it is parked just for
Mm-hmm.
sale, but still some kind of bad faith needs to be proved for
Mm-hmm.
the complainant to be successful against the domain name registry.
Mm-hmm. Okay, that means, tell me whether I am right or wrong. That means if I'm a domain name investor, right? And for some good domain, suppose I'm buying, $200 or $500 domain name from aftermarket, sometime $1,000, right? Correct me if I am wrong. Can I go this way? Like I do Google search with that particular keyword. I mean, the exact domain name minus .com. Do Google search and do some time archive.org search also, and I can take PDF of that search also, and I can also go to LinkedIn or Facebook platform to check whether that particular keyword is in social media or not. Can I do this way? Like, can I prove something like I have done proper due diligence before buying this particular domain name? And I, I I have no malified intention to blackmail some company or to sell this company for super high unreasonable price. Can I do that?
Yes, of course, this is
Does it make any
really
sense?
could be. Yes, yes. If because in any kind of UDRP proceedings, you need to show that as on the date you register a domain name. Suppose you registered a domain name 2 years back, but
Mhm.
now the UDRP comes in 2024 and you register in 22. Then there are not enough tools that will show that what was the Google page,
Thoughts
Google
then.
search
Yeah.
displaying as on that date. So
Uh-huh.
if you are able to save such a search, then and if was not showing any such result, it is quite helpful. Very, very good evidence.
Apart from saving, what can be done? We can use free screen recorder tool, and we can record the Google search screen or Bing search screen using that tool. It
I
will
think
take
it may
hardly
could
five,
be
seven
difficult.
minutes to do so.
It could be difficult to present a video evidence, so it's better to
Okay,
have a
okay.
PDF.
Better to take
Yeah,
PDF. Okay, no problem. No.
PDF that is also good evidence with proper
Right, right.
footers of the URL. Yeah.
Fine, fine. Now,
Otherwise, like trademark
about
search, we were also
tell,
talking where
tell
to
us
check for
about some
trademark
trademark
application.
websites, and
Yeah,
last some case studies. After that, we will take questions from the audience.
for the trademark search, I think the WIPO Global Trademark Database is the best source because it provides results from the various countries, including India.
Mhm.
So if you are able to get some kind of, like, if you register a domain name and you are not getting any kind of search result in there, then you are always on a safer side and you could be more confident in registering a domain name. But in case there are some trademark that similar to domain name are appearing in a search result, then it also depends that if there is an exclusive owner for that exact keyword or brand name, or if there are multiple users. So if there are many hundreds of results or even 50, 60 results, and there are, say, 10 different companies that are holding the same similar trademark in different countries because it contains a quite a common combination. then still it is quite safe to register such a domain name. So that is the best source out, but it is always advisable that never mention in a UDRP proceeding that you did a WIPO global trademark search, because it's better to show uh, that you did some local search only, like we are talking about, that you keep the evidence. So it's better to you can keep the evidence of Google or a local trademark search, but can do a WIPO global trademark search for your own record, but better to avoid to present it to a WIPO panelist so that he is always aware, okay, domain registrar are quite aware. They could, in any case, they will say, okay, see, in such matter, someone said, I made a global trademark search. So that means
Exactly.
everyone is aware and they could have located about other trademarks. So it's
Exactly.
better to show we did a local trademark search and we did a Google search, and not even go into Facebook, LinkedIn. Two things are enough.
Enough, enough. I
Don't
mean,
go
it's
into such.
better to, you know, keep yourself low profile. I mean,
Yeah,
don't try to be over smart with them, you know.
yeah,
Otherwise, they will say, भाई तू इतना smart है तो तूने तो सभी कुछ कर लिया होगा.
yeah,
Okay, no problem. And
right.
I mean,
Because
we.
once this happened, I'll tell you, uh,
Mhm.
I lost that case because what happened was we said that we did some Google Translate search, and this is a quite a common word, right? Then they started blaming us that if they could do a translate.google.com, why didn't they do google.com search? So you are
So,
right. Sometimes if you try to argue something additional, then they may. In that case, it was a stolen domain name, so Panelist was a little favorable to complainant. Still, we could have protected that domain name, but they tried to find out ways out to hand over the stolen domain name. Though my client was not the person who had stolen, he was just a bona fide buyer of the domain name, and such matters could be better handled with a civil court and should should be dismissed at the UDRP level.
questions from the audience, and in answers, Ankurji, you can also include some of your case studies or some of, universal case studies of domain dispute, of course, right? Audience, come on. uh, uh, Ankurji, can you read chat box?
Yes,
You can take, I mean, from there.
so this first one related to State Bank of India. So I'm not getting the question, the first one. So let's come to the next one. I've seen quite a few UDRP with this one. So, as Akshay asked, that in many cases under the UDRP, the respondent do not respond. So, yeah, it happens. Now, there could be multiple reasons. Firstly, someone may not have provided, say, proper who is information. So, he may not have received the information as to the proceeding. And secondly, someone may be aware that he had deliberately registered some trademark-based domain name, so he could have avoided replying to such a uh, complaint. Otherwise, normally, if someone has a legitimate right, I think they normally go and reply to the proceeding. Even sometimes they even try to explain in their own language, or they hire a lawyer. But normally, if there is some cases, some strong case, like I mentioned, 95 to 97% of the UDR domain names under the UDRP are transferred. So mostly those are related to the strong trademarks. So in those matter as well, mostly those are ex parte. Those respondents do not come forward. But when you have some proper legitimate interest, or you are holding the domain name as a domain name investment, then you can always try to respond to the matter. It always helps.
Yes, Sharik, you can ask. You can ask about any domain name. Okay, no problem at all. And I
And
can
Akshay
also cut
asked, yeah,
Q&A session from the webinar. No problem at all.
and as Akshay asked, the second question related to it, does it because a genuine domain name investor do not want to get into UDRPs? So, as I suggested, it is better in the UDRP that you try to surrender a domain name and try to get the proceedings terminated. That is a better way out so that your name does not feature in any UDRP, because just by not responding to a UDRP does not help, because in a UDRP decision that is made public, your name gets featured. So by not responding may not help, but by responding or even try to surrender a domain name will always help a domain name investor. So coming to the next question, as Ronak asked, I own the domain name gogas.in. So I think it's a combination of a quite a common, though if we are doing a Google search and if it is not giving any such result that someone is holding rights to it, let me do a quick Google search. Okay. Okay, it seems that GoGas is already in use in India by some LPG company. So in such case, you need to check if there is some kind of trademark registration or what kind of rights they are holding. Because if they are using this, though GoGas is a combination of common word, but if they are the exclusive company, that is the only company that is using such keywords, then you need to check that since when they are using and when did you register a domain name. Either so, if they are a prior user, then it's always better to avoid holding this domain name, or at least try to see, otherwise you make some kind of legitimate use on the domain name, as it could be controversial in holding such a domain name. Then coming to the next question, as Sharik asked, I have blync.in and .xyz. Okay, this is also related to some brand name. Then of course, the similar thing that I told about the Go Gas, that you need to check, because it's a kind of, it's not simple blink word, it's a kind of a distinctive mark that some company is already using that is related to bikes. So I think issue could be there. So it is better to check the history of that company since when they are using, and try to avoid such domain name. Okay, coming to the Pranav's question, do domain registrars have any stake in filtering out trademark names? No, normally domain registrars do not take care that if someone is what kind of domain name someone is registering, except that now there are some domain name abuse policy like India also has, and some domain name abuse policies, some, yeah, domain name abuse institute is there, of which some domain registrars are members. So such registrars try to participate in such program to avoid domain name abuse. So they may try to filter it out. Otherwise, normally domain name registrar allow even the trademark domain names, because they cannot be sure that if someone is cyber squatting on a trademark, or if someone is registering a domain name on as an authorized person for a trademark owner. So there could be issue. So it's difficult to tell. Okay. As to the domain name Air Chief Marshal and all this related to Army, Air Force, this could create an issue. So it's better to avoid such domain name. because normally you cannot use the such domain name or even cannot offer such domain names to a government office. So I do not think.
I
Okay,
think
it's a .com domain name.
this could be serious offense, I guess.
Yeah, mostly, yeah, they may assume that it could be more of a misuse. Yeah, yeah, these should be avoided. Yeah. Okay, next question. What is the process to get a trademark of any name? So basically, trademark application can be made to a trademark registry. So normally for an individual, the official fees comes to 4,500, and for a company, other than individual, it is 9,000 rupees plus any professional fees if you are going through an professional. So normally, once an application is filed, then the trademark registry reviews the application and may raise some objection if there are any similar trademark already under a similar class. So accordingly, if there are no objections and the trademark application goes to the trademark general, gets published in a trademark general, then the public gets 120 days time line to file any kind of objections. So normally uh, you can get a trademark registration within a period of say 10 months normally, unless and until there are some delay at the trademark office. So you can approach a lawyer or anyone through which you can get a trademark registered. Coming to the next question, can we book chat plus table? Yeah, if it is a common chat plus table is a combination of a common word, and I do not think there could be any issue as to the word table with the word chat, such combination. But let me do again a Google search. It's in quite a common use. There are no issues. Coming to Akshay's question, what if I register a generic world.com and world is already trademarked by multiple companies in multiple classes? Yes, you are safe, because if it contains common word, then it's quite common that in different company, many people may have independently adopted the same common words. So if it is in wide third party use, you are quite safe. About Ronak's question, how strong Indian government laws against trademark domains or any short case study about that? Recently, Delhi High Court is coming up with some strange kind of, though they contained quite strong trademark, like Star TV filed for a complaint against some domain names, and all the domain registrar that are located internationally, like Dyna.name.com, Namesilo, Namecheap, everyone was made party to the matter. So not exactly government, but through courts, the trademark owners are enforcing such rights. And even you have heard, you cannot access dyna.com as on date in India, but you need to access it through dyna.cn or d.in. So these all were as a part of a ruling by the Delhi High Court in a trademark matter only, which uh, made the High Court to pass an order against any registrar who was not complying with their interim injunction orders. Godesso has no registration with Goddess. No, it's fine. Coming to Sharik's question, yeah, it's fine. For Godesso becomes quite a distinctive, and Goddess, even if it has more than 3,000 plus trademark registration, but it is quite a common word, so you can always register. There could not be any such issues with that.
Okay, thank you for joining today's webinar, guys.